Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I would like to talk to those people who have crimes in California, meaning that they have a conviction or had a conviction that was committed in the state of California, and they can't move forward with their immigration petitions and or have been deported, and they can't get back to the U.S. There's lots of different waivers that are available for lots of different kinds of crimes in immigration law, and if a waiver is available, then there's no need to do criminal relief. Okay, the criminal relief, which is going back to criminal court, is done only because you have no other options. Okay, because you can't do a waiver, you can't have your spouse petition you, you can't be petitioned by your children, you can't get a deportation order removed, you can't get back to the U.S., and so forth, or you're in the U.S. and you're hiding. Okay, and so there are ways of looking at these particular crimes, and while each one is somewhat individual in its nature as to the plan of attack and what needs to be done, there are several different vehicles in the state of California that will allow the criminal relief to go forward. Now, when I say criminal relief, what I'm referring to is all of the different types of petitions, applications, motions, and so forth that can be done in the state of California to help you, okay, to try to essentially make it so that you're no longer an aggravated felon under immigration law, and or you're able to go forward with your immigration petition one way or another. Obviously, you should come and see me or give me a call to get a full and detailed consultation, because you can't look at the crime itself and just know what to do. Okay, but this particular video at least gives you an idea of what there is out there in order to help. Now, first of all, let's just start. The general rule with what I refer to as rehabilitative statutes are essentially when, for example, you commit a crime in California, you're a good boy for however long, you finish your probation, and then the judge says, okay, fine, you finish your probation, you didn't violate it, so therefore we'll enter an expungement on this particular crime so that it is dismissed and essentially no longer exists on your record. Well, for the most part, rehabilitative statutes are not valid to erase the conviction for immigration purposes. For immigration purposes, it still exists. However, the reason I bring this up is because there are cases, especially as ruled in the Ninth Circuit, under the Federal First Offenders Act, okay, or the FFOA, as they say. This deals essentially where someone has been convicted of a first offense simple possession of any controlled substance, okay? And this is key because let's say, for example, you have possession of cocaine, okay? The possession of cocaine is not waivable. There's no waiver for possession of cocaine. The only possession crime for drugs that is waivable under immigration law would be possession of marijuana under 30 grams. Well, that of course excludes everything else. Possession of ecstasy, of crystal, of meth, of, I could go on and on, in which I don't actually know all of them, but there are a lot of different drugs that you could be convicted of for possession, simple possession. So, if it falls under the Federal First Offenders Act, and it is a simple possession, first offense, then what you can do is get that case expunged, Okay, and even though it is expunged under a rehabilitative statute, this is an exception to the general rule, such that under case law in the Ninth Circuit, which California is in, it will not be considered a conviction for immigration purposes, and therefore, if this is done, you can go forward and with either the immigration petition or whatever it is you need to do in immigration. So keep that in mind, that for your purposes, if you have a simple possession of any drug, the expunging it under the FFOA may be sufficient in order to erase it for immigration purposes. Okay, now there are different expungement statutes, okay, and the one I was referring to before, the general, which is known as 1203.4, the general expungement statute is not available to help generally immigration, but there are different expungement statutes, such as one for expungement of youthful offenders. Now, certain youthful offenders tried as an adults and sentenced to California Youth Authority may be eligible for dismissal of the charges under this particular statute, and it may be effective in order to show that that particular crime does not hurt you for immigration purposes. Okay, so that's generally the issue on rehabilitative statutes. Now, what else exists? What other items in California? And you know, I'm doing this specific one in California. You know, each particular state has their own string on immigration / criminal relief. A lot of it is relatively similar. However, I wanted to concentrate on California for this particular video. Now, another type of motion you can make in California courts is under what's called Penal Code Section 17b3. Now, this applies essentially to convictions which are known as wobblers. Okay, those are ones which could have been sentenced either as felonies or misdemeanors. So obviously, if you have a crime that can only be convicted as a felony, this isn't going to work for you. Okay, it has to be a wobbler, and then sometimes it's difficult to look and determine. You have to, what we attorneys do is we analyze the statute, we see if it's a wobbler, see if it can be convicted as both. Even if you were convicted as a felon, okay, and the crime itself is a felony, if it could have been also, under certain circumstances, convicted as a misdemeanor, well then you could use this motion. And what it does is it reduces the felony to a misdemeanor, and it can also be used to reduce a misdemeanor to an infraction. Okay? So, obviously, if on one hand, if the misdemeanor is reduced to an infraction, then it may make it so that it is not a crime making you inadmissible in any way, and you don't need a waiver, you don't need anything. So that is a particular motion which you should keep in mind. If it is a felony, okay, and you want to reduce it to a misdemeanor, then you may be able to avoid the aggravated felony status for certain crimes of violence, and you may be able to be eligible for other forms of relief. Now, notice I'm saying may a lot because, there are different facts for each particular case, and this particular video is an overview of all the types of relief that exist. A lot of people think, once they get the crime, that's it, and there's nothing they can do for the rest of their lives, and they'll either stay out of the country or go on hiding forever. And so this video will show the different forms that are available. So that would be a 17b3 motion. Okay. Now, what about other forms? Well, there's what's known as a vacation of the judgment by extraordinary writ. Okay, and essentially what this does is it vacates the judgment on the ground of legal invalidity, basically that existed at the time the conviction arose, and if it is approved, if it is granted, it will eliminate the conviction, including the conviction for drug offenses for immigration purposes. Okay? This may even be able to assist a non-citizen who has already been deported, upon which you can file a motion to reopen afterwards. So another one item with this is if it is vacated because the judge is sympathetic to the immigration consequences, let's say the person has, some kind of medical problem, and, we go back to criminal court and we make this motion to vacate through extraordinary writ, and the judge says, yes, I do see your point, you served your time, you have not violated anything since, and I see you have some medical problems, so yes, I'll agree to vacate. That by itself will not be valid in immigration law. Okay, under immigration law, it's still a conviction, so it cannot be vacated for the sole purposes of immigration law. Okay. It needs to be vacated on the merits, among several other reasons, but not just based upon, essentially that the judge is sympathetic to the immigration situation. Now, there are different forms of trying to vacate a judgment by extraordinary writ. One of them is called habeas corpus. Okay, probably all of you have seen some television show in the past, one way or another, where you have heard of habeas corpus, but the habeas corpus is a common petition for granting these particular motions where the claim is that the criminal defense counsel did not properly inform the defendant of the immigration consequences of the plea bargain. Okay, it is not only used to vacate the guilty plea, but it can also leave the conviction intact, but it can vacate the sentence. So, for example, if you have a crime of violence over a year and you're now an aggravated felon, if you vacate the sentence but leave the conviction, then there's no longer a sentence of over a year. You're not an aggravated felon. You qualify now for a waiver under immigration law, and you can move forward. So you can try to vacate the sentence only. Now, the issue with the habeas corpus is that in most circumstances that you have to be under some form of restraint, of state restraint, such as probation or parole or something to that effect at the time the petition is filed. Now, there are ways to claim that there's constitutional impositions and so forth, but it does make it much more difficult in which to get it granted. So if a habeas corpus is going to be filed, you want to make sure it's filed while you're still in probation or while, before parole expires. Then it's much easier to show that you're under some kind of state restraint in order to try to get this approved. Okay, another form would be what's called the writ of error of quorum nobis. And generally that's where a fact existed that did not go to the guilt or innocence, but would have prevented the rendition of the judgment if it had been known at the time. Now, I'm not going to spend a lot of time on the writ of error of quorum nobis because there was a decision that came out at California Supreme Court which essentially invalidated this for immigration purposes, minus some very narrow exceptions, which, if you give me the chance to give you a consultation, I'll see if you fall under one of those narrow exceptions, but for the most part, error of quorum nobis isn't super helpful at this point. Now, in California, there's also the state advisal statutes, which is Penal Code 1016.5, where the judge has to give specific warnings about what might happen if the plea is given. The claims here are raised on motions to vacate based on the statute itself. I have found that for the most part it's almost pro forma. The judges for the most part will say it, but you have to keep in mind that these advisals were mandated based on the law in around 1978. Obviously, immigration law has changed tremendously since then. So to hold that the same advisals exist today that should, had existed in 1978 is a little bit silly, and it definitely should be updated to provide the real consequences that might go forward. But anyways, that 1016.5 motion is available. Obviously, when you do a criminal relief motion based upon that, you need to get the transcripts, you need to see if they were given and what exactly was said and so forth. Okay. The other would be a non-statutory motion to vacate. That could be a motion where you look at the ineffective assistance of counsel or any other grounds of constitutional error showing violation of due process and so forth. And then, of course, you have to document why all that happened. And these are not easy motions, but they certainly are doable. Another one would be the motion to withdraw the plea. Okay, in this particular case, you want to try to get this motion out within 6 months after you made the plea. Now, a lot of people, in fact, the majority of people who walk in my door, their conviction was years ago, so this won't really work. But for those who did plea within 6 months, you could withdraw the guilty plea for good cause, and that'll be under Penal Code 1018, and that would eliminate the conviction for all immigration purposes. Okay, and so as you can see, there are several types of relief that's available. Another would be a gubernatorial pardon. Okay, a gubernatorial pardon will eliminate the immigration effects of the crime involving moral turpitude or an aggravated felony. So obviously, if it was not an aggravated felony or one involved with crime of moral turpitude, then we have some issues. But it is doable and it is possible to send a petition to the governor to try to get it vacated if the criminal courts didn't work, or if that's the first place you might want to start. So in any event, as you can see, I've gone on the majority of types of different petitions that would be available in California. It certainly is doable. They all exist because of essentially the reason you need to have it vacated and or reduced. So if you like the video, click like and subscribe. Also, feel free to give my office a call and or email to set up a consultation, and we'll go from there. More on the coming videos.